The legal implications go well beyond just Jammu and Kashmir. And what are those implications? Joining me now, Satyapal Jain, former Additional Solicitor General of the country, who's been also a BJP MP in the past. Shadhan Farasat, Advocate Supreme Court. Appreciate both of you joining us. I want from both of you first, right at the outset, you, Satyapal Jain, your biggest takeaway from this judgment. What, according to you, is the biggest constitutional takeaway from this judgment?
I think the Supreme Court have once again affirmed the sovereignty of the Constitution of India by saying that the powers exercised by the Parliament, the President of India, under the Constitution of India are valid and they have been upheld by the Supreme Court. A message has gone to the whole world that as per the Indian Constitution now, the Jammu and Kashmir has always been and will be an integral part of the Indian state, and any other argument by either Pakistan or by some people in India that it's not an integral part of India now has gone. And thirdly, the Indian Supreme Court also says about the holding of the elections in the state, restoration of the statehood also. It's a very balanced judgment which has been delivered by the Supreme Court, and it establishes that the Parliament, the executive and judiciary, they are supreme in their own fields, but ultimately sovereignty is that of the Constitution of India. And now, as per the Constitution, Jammu and Kashmir is an integral part of India.
You know, but the fact, Satyapal Jain, is one of the possible repercussions is tomorrow, if a state is under president's rule, it can be carved out into union territories simply by majority in parliament. Today it's happened with Jammu and Kashmir. Tomorrow it could happen with any other state. And the Supreme Court has chosen not to intervene in the process. Is that not worrying? Is that not something that should be concerning?
Because of the reason. No. Because of the reason that under Article 3 of the Constitution of India, this power vests with the Parliament, and Parliament has been exercising these powers earlier also. I am in Chandigarh. Take the example of Chandigarh. In 1966, when Punjab was partitioned into Punjab, Haryana, and some areas were given to Himachal Pradesh, at the last moment, in fact, the Shah Commission had recommended that entire Kharar Tehsil, including Chandigarh, should be given to Haryana. But at the last moment, the then government led by Srimati Indira Gandhi decided to make Chandigarh as a UT. And it is UT after even about 50 years. That is the power vested in Parliament. And Parliament consists of representatives from all the states, all sections of society. We should have faith in Parliament. And do not forget, the Constitution has given the power of making laws, making states, making alteration in their boundaries to the Parliament of India.
Can I bring in Shadhan Farasat? For you, what is the biggest takeaway, Mr. Farasat? You're on mute. You're on mute, sir.
There were two aspects in this matter. One was the 370 aspect and one was the conversion from the state to UT aspect. On the first 370 aspect, the Supreme Court has not accepted the government's mechanism of doing this. And they have said that actually the amendments which you made to convert in the Constitution a constituent assembly into a legislative assembly, that power you did not have. However, they have then gone on to approve it on a different basis, which is that under Article 370, once the Constituent Assembly of J&K ceased to exist in 1957, the President of India could have unilaterally revoked the provision at any time. That, to me, to be honest, that reasoning of Supreme Court is quite surprising. And because if that was the case, then really speaking, 370 was not a protection at all. Because any time after the Constituent Assembly ceased to exist, all the President had to do was a unilateral declaration. So that reasoning is quite surprising to me. Although they have not accepted the government's way of doing it, they have nevertheless upheld the revocation.
No, they've accepted that the reasoning they've given, from what I can see, Shadhan, is an interesting concept called asymmetric federalism. They seem to suggest that giving this special status to Jammu and Kashmir was a temporary provision. Had it been permanent, it would have created what they seem to believe, or at least Justice Sanjeev Khanna seems to believe, is asymmetric federalism.
No, so the judgment recognizes that India has many aspects and many examples of asymmetric federalism. But even whatever metaphor you may use to describe it, there's a mechanism of a change there that Article 370 itself had. Now, for the Supreme Court to say that, listen, once the Constituent Assembly ceased to exist, the president could have unilaterally done it. Therefore, effectively, any government, what they are saying, from 58 onwards, any presidential order could have unilaterally revoked 370. Then what was the meaning of that protection? I mean, I find that, I mean, I will put it, I find that reasoning quite surprising. However, they have not accepted the government's route of doing it, which is to amend 367, then make the Constituent Assembly, Legislative Assembly, then the Legislative Assembly acts as a parliament and then does this. So that's a technical thing. I think the reason the court has not accepted the government's reasoning is the court was at some level conscious of if you allow a government to do something in 356, that is precedence rule, to change the nature of a state in the manner in which it has, then or change something as fundamental as 370, then there will be problem not just for J&K but also for all states around. So I think they have consciously avoided going the government way and therefore come up with this solution. That's on 370. Now we come to state versus UT. On state versus UT, the question was directly before the court, that whether this conversion from state to UT is permitted under the Constitution. And therefore, just allow me a moment. The real question was, can you extinguish a state completely into two UTs, that no portion of the earlier state remains as the UT? Does the Constitution permit that? And they have not answered that question. And I was slightly disappointed with that as well, because that question was directly before the court. Undertaking by a law officer to the court cannot in any way, especially when the undertaking didn't have a crystallized timeline, cannot undo that. So therefore, my expectation was that the court will answer that second question. And that was really a slightly easier question for the court to answer, whether state versus UT.
Let me just take that to Satyapal Jain. You make a very important point.
The court has said that September 24 you will do elections.
Yes.